activities of his intent.
How's the possession of drugs, a firearm, and all that cash related to the casino? It happens to be in his car, but is there any link between that and the casino?
Yes, Your Honor, but for Mr. Moniguag's intent of entering onto tribal lands to gamble, those individual substances would not have arrived onto
Counselor,
tribal
what
lands.
happens to your analysis if we agree with the appellant's argument that this occurred in the parking lot and that he never got into the casino? He never engaged in gaming or any sort of economic activity on tribal lands.
Well, Your Honor, there are two additional sources of a consensual relationship. The first would be the intertribal agreement as co-counsel spoke of, and the second would be the relationship with Mr. Dickey Day, in which money was exchanged with a tribal member of the Rabbit River.
It wasn't money for drug-related deals or weapon-related deal. It was, as a matter of fact, they were fighting about other money, not about the money that Brian Dickey Dare, he might have known, but nobody was fighting about that money.
The money was related specifically to gas money and the truck.
But the gas money is not the 25 grand inside the Federal Bar Association Indian Law Section bag.
No, Your Honor, but it was inside the truck that the gas powered. But even if this information is not enough to establish a consensual relationship under the first Montana exception or establish a nexus, the tribe only has the burden of proving one of the two Montana exceptions, and here the second Montana exception clearly applies.
Has the U.S. Supreme Court ever applied the second Montana exception successfully in favor of a tribe?
No, Your Honor.
Do you have any case law supporting your assertion that we should do so?
Yes, once again in the 8th and 9th Circuit. The 9th Circuit in Babbitt 4 in 1984, and the 8th Circuit in Attorney's Process. Both those cases are very helpful in this instance because once again they involved activity that occurred on tribally owned land, and they demonstrate that there is a lower standard for determining what activities can be regulated under the Montana exceptions when those activities occur on tribally owned land.
Yes, because possession of firearms, the drugs, and probably laundered money or drug money in any way, how does that affect the political integrity of the tribe, if at all?
Well, Your Honor, 25 U.S.C. Section 2401 states nothing is more costly to Indian people than the consequences of substance abuse. And 4 out of the top 10 causes of death in Indian country are substance abuse related. Here, Mr. Moniguag's.
Then you would be pointing out the health and welfare, not political integrity. So there's several possibilities: political integrity, economic security. So are you focusing on health and welfare of the tribe?
As well as economic security, Your Honor. Because the activity occurred at the tribal casino, the mere presence or the mere perception of presence of marijuana or of a drug deal at the Indian casino could have.
No evidence here that there was actually going to be a drug deal at the casino or elsewhere. It was found in his truck, and that's a fact. But how can you link that money to the casino?
Well, Your Honor, the forfeiture statute itself states that the mere presence or the mere perception of a presence of drugs on tribal land would be detrimental to the tribe's economic security.
You start talking about the forfeiture statute, but again, I asked the question I asked co-counsel. Again, isn't that statute the underlying nature of the evil there, the drugs, the weapons, the drug money? That's an illegal act. It's a criminal act. This is not like a forfeiture statute that says, for example, if you have an excess of, like a regulated activity says, if you have an excess of 10 bottles of liquor purchased at the tribe, you will forfeit anything in excess because you can't have it. That's not a crime per se, but it's regulated, you can forfeit. Isn't this really forfeiture based on a criminal act? Because if you look at all of the facts, the other gentleman who got into the fight, he's been prosecuted. The feds are investigating their client, Manitowoc, for these acts. And this smells criminal all over to me. And why shouldn't the feds or the state prosecute this crime rather than as a crime and reservation continue doing it in a civil way? It's basically interfering perhaps with the federal government or the state's ability to prosecute Manitowoc.
Well, Your Honor, the question brings me directly to my final point, which is the question of whether the forfeiture is civil or criminal is a moot point because the Rabbit River tribe had both civil and criminal jurisdiction over Mr. Moniguagh. As co-counsel has pointed out, the scope of this court's review is extremely limited. And opposing counsel has cited to no authority that would allow federal courts to review a tribe's choice of jurisdiction when they have the ability and the jurisdiction of both civil and criminal.
But again, it's a little circular because on the civil side, you only have it if you're successful in Montana, and so if you lose on that, then it's not a good point.
Yes, Your Honor.
How do you have the criminal jurisdiction? I just don't get it.
Well, the 1990 Indian Civil Rights Act amendments, as affirmed by the U.S. Supreme Court case of Laura, states specifically that Indian tribes have criminal jurisdiction over non-member Indians, which Mr. Monty Dewald most certainly is.
Counselor, I want to go back to your argument before that this satisfies the second exception in Montana, that the mere presence of the drugs and the gun satisfied that exception. How is that? How is this different than straight, where they basically said the mere possibility of auto accidents on the reservation might engender health and welfare, but they found that it wasn't sufficient to satisfy that second exception?
Your Honor, straight, as well as the remaining Supreme Court cases, with the exception of Hicks, involved activity which occurred on land that was not owned by the tribe and thus had the heightened standard for determining the exceptions. In the 8th and 9th Circuit cases I've cited to, they established a lower standard, and that standard is this: conduct which is reasonably likely to result in violence on tribal lands sufficiently threatens tribal health and welfare to allow for regulation under the second Montana exception.
Has the Supreme Court affirmed that lower standard?
No, it has not, Your Honor. But we are asking this court today to adopt that standard when the activity occurs on tribally owned lands, as it has here.
But the 8th Circuit case is a dramatically different case in that about the civil case apply one faction against another, and here you have one isolated act. I mean, are they really that similar?
Well, the 8th Circuit case provides an extreme example, but the 9th Circuit case, that of Babbitt 4, provides an example more pertinent to this case. In that instance, the Federal Circuit Court in the 8th Circuit affirmed a tribe's jurisdiction to regulate the repossession of automobiles under the second Montana exception because it found that repossession of automobiles by non-members on tribal land could sufficiently result in violence to threaten tribal health and welfare. Here, Mr. Monty Dewald's activities are far more harmful than a few repossessions of automobiles. In this case, not only do we have the threat of harm as indicated in the second Montana exception, but we have actual harm through the fistfight and through the presence of marijuana.
Is that actual harm though to the tribes, just to one tribal member?
Your Honor, the presence of marijuana on tribal lands, assuming it was known to others, would harm the economic well-being.
Was it known to others?
From the facts, we don't know, and we are willing to concede that. But simply because the marijuana was present on tribal lands, and the statute itself states that the mere perceptions of presence on tribal land would have a negative effect on the tribe's economic well-being.
So if we accept that argument, then the tribe has jurisdiction over every instance where there are drugs on the reservation?
Any incident of drugs on the reservation which would cause harm to economic security, in which we argue it does.
Wouldn't that be an exception to swallow the whole rule?
Your Honor, specifically in this instance, no, because the activity is on tribally owned land. And that language of the exception, swallowing the rule, applies only when it occurs on tribally owned land per se. In other words, that language references when an individual enters onto tribal land. The courts have stated more is needed than simply entering onto tribal land. Otherwise, the exception would swallow the whole rule.
Mr. Copper, you have very little time left, but I'd like you to clarify. Are you saying that it's irrelevant for our analysis whether the contempt citations issued here were civil or criminal?
Yes, Your Honor, and if I may briefly run through that analysis. In the 9th Circuit in Quichan versus Roe and in the Utah District Court case of Leiter versus Tabone, those courts analyzed a tribe's use of forfeiture and civil contempt and found both to be criminal in nature. Both cases asked the second question of whether or not the tribe had criminal jurisdiction. In one case they did not, but in the circuit court case, the tribe did have criminal jurisdiction. Because of that, if I may conclude briefly, the federal courts found that the tribes had discretion to choose which type of jurisdiction, mainly because the federal courts could not review ICRA violations. Thank you.